So it's just 1 o'clock now, so we're going to start bang on one, as I think this is a really interesting topic and we have a short 30 minutes to talk about it. So firstly, I'd like to welcome everybody to today's webinar, which is discussing the topic of the rights of parents who are in custody or incarcerated in an Irish prison setting. So my name is Niamh McCarthy. I am Head of Services for the Parental Advocacy and Information Service, which supports parents of children in care, navigate care proceedings and court proceedings, and supports them in that. We also run a clinic in the Joker Centre, which is an Irish prison for women in custody, every Thursday, and we go in and we help mothers who are in custody and their children are in care to access and participate still in the care proceedings. I am joined this afternoon by Stephen Cahill, who is the Managing Solicitor for the Legal Aid Board in Chancery Street. And this webinar is recorded and will be available on our website and the Legal Aid Board website as well, as along with our previous webinars that Stephen has participated in as well. And there will be a slide at the end, if I can get my slideshow working. It was a bit dodgy this morning. So if that's working at the end, there's a QR code, but we'll put it in the chat that links you to our various websites as well and our previous recordings. We do encourage people to use the chat for any comments, questions they'd like to put. And if we don't get to it in this webinar, we will get into it in future webinars. So I suppose in relation to parents who are arrested, they may be on remand, they may be facing sentencing, or they may be sentenced and they go into one of our Irish prisons settings, or they may be held overnight in a Garda station. For those parents, there's various different scenarios that could affect their children and their children going into possibly the care of the Child and Family Agency, TUSA. And we just wanted to discuss some of those scenarios today and kind of put some questions from a rights perspective to Stephen and what parents should do in these situations as well. So I suppose the first scenario we were thinking about, Stephen, and many parents come to us, is that it's an emergency situation. They've been arrested, they've been remanded, they're sometimes not 100% sure where their children are, if their children have been placed with a relative or if they've been taken into the care of TULSA. And in some of these cases, there may be an emergency care order that is sought after. And we're just wondering, in that a case of emergency, will it go to court, or what happens in those cases?
Yeah, so I think you've very fairly and correctly set out just what a difficult and kind of stressful situation that can be for a parent who might all of a sudden find themselves having been arrested, or even if they find themselves on the receiving end of maybe an unexpected sentence, that their priority is going to be who's going to look after their children. But I think a very important starting point to recognize is that even if you are arrested, even if you're convicted and sentenced, none of those things interfere with your rights as a parent. You are, for example, if you're a child's mother, you're their sole guardian. No conviction, criminal sentence interferes with your rights as a parent or a guardian. It's only if you consent to alternative arrangements, or if TUSLA are forced to obtain appropriate orders in the childcare courts, that might interfere with rights. But the power is very much with the parent still at the beginning, at least.
Okay, very good. And if there was nobody appropriate, or I as a parent couldn't identify anybody in that moment, so I presume then TUSA would have to step in, or and would be looking for either an alternative family placement, or sorry, go ahead, Stephen.
Exactly. So ideally, and recognizing that it's still your decision as a parent, that maybe the guards or TUSLA, if they're involved, would, in conjunction and collaboration with you, try to put in place appropriate arrangements that you are in favour with. And I think you've referred to there in particular, maybe what's called a private family arrangement. So ideally, you as the parent in custody would have hopefully a parent, a relative, a neighbour who might be able to step in while you're, I suppose, while you're detained and not in a position to act. It's only if you're not able to identify an appropriate arrangement, or you're just simply not agreeing to any arrangements being put in place, that TUSLA would stand over. That TUSLA would then have to seek appropriate orders. And in that instance, yes, they would most likely apply for an emergency care order in the district court.
Yeah. And I suppose that's a really important point that you've made. Just because a parent is sentenced to a sentence or is remanded on custody, that is not an automatic trigger for TUSLA involvement, that you're still the parent and there can be alternatives in terms of accommodation for your children. So in some cases, obviously that will work out fine, and in others, there may be involvement through the courts. And if the first step is an emergency order or an emergency care order, maybe a Section 12, can the parent attend that hearing, or what happens in those cases?
Yeah, so ideally, a parent will always be present and legally represented for any applications being made to do with their children. They're extraordinarily important applications. And as a parent, you've fundamental right of access to justice and representation, if at all possible. It's sometimes the case that if a parent has been arrested, that the guards may not facilitate them attending court because there may be questions, they may not be fit for release at that point. But ordinarily, a parent, if a parent is in DOCUS, for example, the parent should be produced to court. The court would ideally be able to wait and facilitate that parent's attendance at court. But it does arise sometimes that parents, notwithstanding that they would want to be present, simply can't be produced or brought there on time, and the court is forced to deal with this emergency situation in their absence. So that does occur absent a parent sometimes.
Yeah, and that's a really good point about representation as well, Stephen. So a parent in this situation may be very overwhelmed as well. They obviously have a lot of shame and stigma about being brought to custody, being away from their children and things like that, may be very overwhelmed in their thinking. And will they automatically be assigned legal representation, or do they need to make the various applications for legal aid?
So any application that's being brought to court by TUSLA will clearly set out the parent's entitlement to legal aid and would kind of advise parents that they should apply for legal aid. And we'll give a list of all of the law centres located around the country to which the parent can apply. The most common situation where there's an emergency application and it's in Dublin, most people would simply apply to the Chancery Street Law Centre because it is co-located with the court. So you're given papers and you might be produced to the court in Chancery Street, and the Legal Aid Board have an on-site law centre there. If you make your application when you're produced, you'll be assigned a solicitor immediately. So we have a very much kind of frontline reactive service there for parents who are trying to respond to these emergency situations.
Yeah. And I suppose then if you were in Limerick prison or down the country, I suppose it's more likely you're attending online rather than being produced. So is there integration with the prison services as well about applying for legal representation?
So these applications to court should be made on notice. So that should give the parent an opportunity to try and obtain legal representation in advance, whether that's through a private solicitor or indeed through the Legal Aid Board. But I think a court would be very slow to proceed with an application where involving children, where a parent is seeking to be involved, looking to be represented, but for some reason hasn't been facilitated. So I think a court will be very slow to go ahead with, for example, an interim care order application where a parent hasn't been produced and it doesn't have representation.
Okay. And then in the cases where parents are going through interim care order proceedings and they do have representation, and I suppose many of our parents who are in custody would ask, how will I get to see my solicitor? Can I be briefed beforehand? Will I have an opportunity to give highlight my strengths, or can I go through the reports with my solicitor beforehand? So how does that all happen practically, Stephen?
Well, yeah, as you said, practically. So there are some practical obstacles to the easy instruction of a lawyer and the lawyer taking full and detailed instructions from you. But your lawyer will make all steps possible to come out and meet with you in whatever prison you may be in, or have arranged consultations via video call. And your lawyer will also arrange for you to be produced to court for any of those applications, assuming they've been on board in good time. And on the day then, the lawyer would be able to go through the most up-to-date information with you and to take your full instructions.
Okay, and is access visits part of the court proceedings then in interim care orders?
Yeah, absolutely. So access is a fundamental part of any childcare proceedings that's recognised in the statute, in the law, that effectively says that if a child is in care, the starting position is that there's an obligation on TUSLA to provide reasonable access to a parent. And there's further case law in respect of parents who are in custody, that just by virtue of a parent being in custody, that does not permit your access rights to be diminished in any way either. So again, even though a parent might be in prison, the obligation is still on TUSLA to provide access, and the parent still has entitlements to access with their children. In fact, it's the child's right of access to their parents that must be vindicated. So it's only if there's a very clear rationale for access being denied and an order of the court allowing no access would a parent be denied visits if they're in prison, for example.
Yeah, and I know that is very nuanced and complex, as a parent may not want their child coming into that setting. They may make that decision. A child may not be comfortable in those settings. There's various different reasons for sensory, and then there's various other alternatives for access. And I know particularly in Jocas, there's alternatives arrangements are made in the best interest of the child all the time as well. So. And that's very interesting. Yeah, sorry, Stephen.
Yeah, no, I agree entirely. And the viewpoint of the viewpoint of the parent is really important in putting in place those access arrangements. A parent may decide that they don't wish to avail of in-person access in a prison, and that's entirely up to them. And but ultimately, the decision should be with the parent in the first instance.
Great. And if, for example, a full care order is in place prior to the parent going into prison or custody, do any of the rights change for the parent in those instances?
So a care order, so even a full care order,
Yeah.
placing a child in care right up until their age of majority, that is not an adoption. That does not displace all of the parent's rights. The parent will still need to be fully involved in the child's care planning decisions. It's just that a care order involves a greater transfer of authority, parental authority, to the Child and Family Agency, but it is not to the total exclusion of a parent.
Yeah. You've just mentioned adoption there, Stephen, so that brings me on quite to our next question. And it's a question many that comes to us on a Thursday a lot. You know, I have a long sentence or I'm sentenced for a few years. Does this mean my child will automatically be adopted? Or in some cases, the adoption has been agreed and is going forward, but the parent may not be in agreement with it. So two questions there. Does a long sentence automatically mean that a full care order will be granted that will then move on to adoption? And then we'll come back to the second part.
So in the event of a parent receiving a lengthy custodial sentence, I think that it does, not necessarily, but it effectively does automatically follow that a care order will need to be made at a minimum for the duration of that parent's sentence. It doesn't follow that it's for any longer than that, but the reality is it could well be.
Okay. So if a parent is in custody and has been informed that that the adoption is being explored for their child, this may have been something they may have been aware of prior to going in, but now the reports are being kind of done. The social worker is ready to go to the adoption authority, and maybe the parent is really unsure about the process. What is their, I suppose, rights in this case?
So adoption is obviously a very complex area. And my starting point is that any parent who is in discussions with the agency or even has an apprehension or slight concern that an adoption might be being pushed forward and they're not in favor of that, that I would suggest that they apply to their local law centre and get appropriate early advices. Because you've already referred to there the different stages of the adoption. So there's the initial inquiries and whatnot, and then it goes through the adoption authority before any applications being made to court. And you're entitled to legal advice and representation along the way. And I think it's very important that a parent would engage in that.
Yeah, because many of the instances we have supported parents in, they've actually been really in favor of the adoption and they can see it as the best outcome for their child and what their child wants, and really put their children's needs first in those instances, in individual circumstances. But one of their fears is always that that will be it then. They will never have contact with their child again. They won't know anything about the updates. Could you talk a little bit about that? Is that a valid fear?
Yes, I think it is a valid fear. Ideally, these things can be done in collaboration and good relationships endure beyond an adoption made. But in theory or in principle, an adoption is the severance of that family connection, of that family right. So you lose any, I suppose, recourse to the courts, for example, in reality. So it is a reasonable fear that parents have. And it's one that you'd hope, if adoption is going ahead, that sufficient agreements are reached and commitments given, that access and whatnot would continue and relationships would be continued to be fostered going forward. But it is, there's an element of kind of trust involved.
Yeah, definitely. We just have a question in relation to, will the child's views be taken into account when dealing with TUSA? And just to say yes, particularly every effort is made to represent the child's views in every meeting, every interaction, no matter what age the child is, that there's age appropriate um, ways of getting the child's views, their opinions, and I think they're all very much represented in the reports, and also true if the case is in the courts and the child has a guardian ad litem assigned to them as well. Their role is also to represent the child's views, but also the best interest of the child. So hopefully that answers that question. But I think it is really important as well. And I suppose and that the child's views, the parents' views, the family's views are all represented in these really difficult proceedings and really difficult time. The next area, which I suppose that comes up a lot, and I suppose in the last year, in Jocus in particular, there was 24 cases of mothers going in pregnant to Jocus. And I suppose if a mother is going in to custody pregnant, they're obviously very worried about what is going to happen if they're on remand or for sentencing. And is there any particularly different process if a parent is pregnant at the time? Or can you talk to us a little bit about that, Stephen?
Sure. So again, the starting point should always be I suppose, the constitutional presumption that the child's best interest is best met in the care and custody of their family, or in their mother, with their mother, ideally. That's reflected, I suppose, in the prison rules. So the prison rules permit for and make provision for, if a child is born to a mother who's in Docus, that the child can remain with their mother in Docus. And that extends right up until they're 12 months of age. And that can be extended further if there's special circumstances. But a child doesn't need to be even born in Docus to remain with their mother in Docus. If a mother has a child under one and is going in for a custodial sentence, could be permitted to enter into Docus with their child. So again, that should be the decision for the mother. If they wish for that to happen, then that should be provided for. And the prison rules provide for that.
Yeah, and I know one of the key areas at the moment that we're facing in all Irish prisons is the overcrowding, which may obviously be a factor that needs to be taken into consideration if there isn't suitable accommodation available to accommodate a child in prison.
Yeah, so the Irish Prison Service do have policies in place and kind of aspirational facilities, I suppose, but they do have on-site fresh access to doctors, things like that. Sorry, I lost my train of thought there with the.
Yeah, no problem. You said there was on-site supports in place for it. The Irish Prison Service has various rules and policies in place to
Yes,
support.
sorry. Yes. So I just had to come back to your point about just there being overcrowding in prisons, and yes, that is a reality. So there is certain pressure on the prison service, but ultimately, if you as a mother are being told that the prison isn't going to facilitate you because of a lack of facilities or because of overcrowding, I think you'd be well advised to speak to a lawyer and see what steps you might be able to take in that regard.
Okay. And is there, I presume there is alternative options, sentencing options, than just solely a custodial prison sentence? That
Yeah.
is there community options or others for particularly mothers and fathers who are the sole carers of their child?
Yeah, precisely. So the custodial sentence should only be a measure of last resort. And when it comes to sentencing or mitigation, that would very much be put to a judge if there was going to be an impact on children that you already have and their care arrangements, or if you were then likely to be potentially in Docus while sentenced and giving birth. So the courts should only approach custodial sentences as an absolute last resort, particularly in those circumstances.
We have another question in, Stephen. So, hi, Neve and Stephen. If a parent is going to be in prison for a number of years and is the main carer for the child, as the other parent has a significant addiction issues, can an adult child who's going to be the main carer for younger siblings share guardianship with the incarcerated parent?
Yeah,
And
I'm sorry. So there is provision in law for people other than a parent to become a guardian of a child. So in Irish law, the mother is automatically a guardian, and the father is, in certain circumstances, automatically a guardian once they satisfy certain criteria. But usually, a father might have to apply for guardianship if they're not married to the mother or haven't resided with them for a requisite period. But other relatives, so for example, the adult child there, can apply for guardianship, but they too must tick certain boxes. And I think one of the boxes there will be that they've actually already looked after the child for a period of 12 months. So it can be slight kind of chicken and egg. If, for example, TUSLA are concerned that you'd have someone looking after a child who's not a guardian, but how do you become that guardian unless you look after the child first? So it's not without its complications, but it certainly can be done.
mm, and I know the court services have recently worked a lot on the guardianship forms and made them a lot more user friendly. And I think they're available digitally now as well for people to apply for as well. So the second part of this question is around also, are you aware of any financial support for a sibling in this position? It's my understanding if you are awarded guardianship that there is a guardianship allowance that can be applied for as well if you are the sole carer.
Yeah, so that's absolutely correct. There's also the possibility. So if a parent goes into DOCUS, and like that we spoke about, unless there's orders interfering with your rights, you still maintain them as a parent. But a child could be received into care even on a voluntary basis. So a child can go into care with the consent of a parent and could be placed with a relative foster care in that instance, for example. So if a child is in the care of the agency, but placed with a relative, that relative is the foster carer and is therefore entitled to a relative fostering allowance, which is a fairly significant support for the benefit of that child. So that's another potential financial support available, but requires the child being in care.
And I imagine the relative would have to undergo a fostering assessment as well to, yeah, to qualify. I think we only have a few minutes left, but I want to just revert back to um, our previous conversation about when a mum does have their child in JOCUS and up to 1 year. It's my understanding then the mum is the sole carer of that child. The child is not in the care of anybody else or a previous relative or the child and family agency. So, um, what are the steps when it's time, say the child is turning 1, it is time for the child to leave, be it JOCUS or Limerick prison?
Yeah, so as you said, if the child is in DOCUS with the mother, that child is not subject to any orders, and there's no interference with the mother's custodial or guardianship rights. The issue arises then when you come close to this 1 year kind of cutoff that the prison rules apply. That you need to start thinking what are the future arrangements to be made. And it may be that if a parent has another month, 2 months to go on their sentence, that the governor would accept that constitutes a special circumstance and might exercise their discretion to allow the child to remain with the mother a little bit longer. But there is the alternative situation where the child is coming towards the end of the permitted stay in DOCUS and the mother is going to be there for a considerable longer period of time, that an alternative arrangement needs to be made. So either private arrangement, relative, in kind of kinship care, voluntary care, or indeed interim care orders.
Thanks, Stephen. I think we could have talk about this forever because it's a really interesting topic. So, but we're just coming up to the end of our time today. I just want to thank Stephen for giving his time to us today and answering all of our questions. And I suppose next week we are going to have another webinar at the same time on the Thursday in relation to supervision orders. So the invites will go out and be advertised there as well. And I am going to try and share my screen, which will include our QR codes to our feedback form, or any questions you may want to put to Stephen, you can put in that form as well. And also our QR codes to previous webinar recordings and to our various websites for information. But thank you so much, Stephen, for logging on today.
No,
And hopefully
thanks very much
works.
for involving me, Niamh. I appreciate it.
Thank you, Stephen. Hoping this shares now. So I think that's sharing with everybody. Yeah, so I'll just give that a few minutes for people to get their feedback in if they so wish, and also take note of the QR codes. But I want to thank everybody for joining us today as well, and we welcome all feedback and any questions or any topics of interest, or any development of these webinars that you could give us are always welcome. Thank you.